is coming from Honorable Member for Akwatia, Honorable Ernest Kumi, and it is about enforcement and responsible mining practices. Yes, Leader.
Mr. Speaker, this House needs to be careful. Mr. Speaker, if you look at our Constitution, Article 1 to 7, Mr. Speaker, if you have a copy of your Constitution, let's look at it together. The Speaker, 1 to 7 talks about the independence of the judiciary. 1272 says that neither the President, nor Parliament, nor any person acting under the authority of the President or Parliament, nor any other person whatsoever shall interfere with judges or judicial officers or other persons exercising judicial power in the exercise of their judicial functions. And all organs and agencies of the state shall accord to the courts such assistance as the courts may reasonably require to protect the independence, dignity, and effectiveness of the courts subject to this Constitution. Mr. Speaker, if you look at our standing orders, it is also clear on your functions and your responsibilities as a Speaker. Let's go to Order 20. Mr. Speaker, Order 20 is clear that the Speaker shall uphold the honor, dignity, and sanctity of the House. Mr. Speaker, the maker of the statement has been convicted by a High Court. Convicted by a High Court. I have read it in the papers. I have read it on social media. And he wants to come and stand in this chamber and make statements so that this House will be telling the courts that it doesn't matter what you do. Mr. Speaker, it doesn't uphold the dignity and honor of this House. It doesn't uphold the dignity and honor of this House. That he has been convicted by the courts, and indeed, the basis of his conviction is the conduct in this chamber. The basis of his conviction is the conduct in this chamber. When he was cautioned that if he insisted and had himself sworn in as a member of Parliament in the face of a restraining order by a court, if the court came after him, he will be accountable alone. We will not be part of it. This was made very clear in this chamber. And he took it upon himself to take the risk. And then he was ready to take responsibility for his conduct. Mr. Speaker, it's time for him to go and account for his conduct. But to come and stand in this chamber and we will all participate in sitting here and listening to him make a statement as if the courts are nothing. Mr. Speaker, I'm not ready to be part of it. So I have strong objections to him reading a statement in this chamber because the courts have convicted him. He should go and appeal against the conviction, have it set aside, and come back. And we have a duty as a House to uphold the dignity, the integrity, and the respect of our courts and the rule of law. He is aware. Your leader on several occasions told the Speaker that even if he was not served, once he became aware of a decision of the court, the Speaker must act on the basis of becoming aware. So it's not a question of whether he has been served. He is aware that the courts have convicted him. He is aware that the courts have convicted him. And he wants to come and stand in this chamber and make a statement. I caution. I said, don't do that. Don't make a statement. So, Mr. Speaker, we have strong objections.
Yes, Minority Leader. I'm a Minority Chief Whip.
Let me allow my colleague.
Afterwards, you wouldn't comment, please. This is not a matter of debate. I'm giving the opportunity to you because you are a leader.
Speaker, first of all,
once you yield it.
Speaker, this is a subject matter which is very important as legal jurisprudence of our parliamentary democracy, and also in respect of separation of powers. It's important, Speaker, we educate ourselves on this matter. And Speaker, I will defer to you. If it is the case that when he speaks, I will not speak, so be it. But I thought that he, being an industry person, we should hear his side or what input he can bring to the matter at table, and then we can conclude on it.
Saying, what I'm saying is,
Speaker, with greatest respect to our colleagues, when the leader was speaking, we all paid attention and listened to him in silence. Why can't you listen to our side in silence? Why? Or the parliament of this republic is one-sided? Is this parliament only one-sided? It's not right. Anytime we are on our speak, you want to interfere. Why? When the leader was speaking, we listened to him. You have to stop this. It doesn't help. Speaker, my point is, please, the greatest of respect, and I'm saying this because we were at conclave, we engaged on same subject matter, and Speaker, you decided to admit the statement. You were not under duress. Speaker, you exercised your powers to admit, and the admission of statement is in the bosom of the Speaker. So the Speaker has admitted a statement, and upon hindsight, some concerns comes up. We all have to bear patience and listen. Speaker, on this note, I pray you that we listen to our colleague. When he's done and you find it needful to listen to me, so be it. Otherwise, we can proceed.
Yes. Mr. Speaker.
Allow. Stand tall. Stand tall.
You wish you could also stand.
Stand tall.
You wish you could also stand.
Stand tall.
Mr. Speaker, I'm very grateful for the opportunity. Mr. Speaker, I am also very grateful to the
Speaker.
Mr. Speaker, I'm also very grateful to the Minority Chief Whip. I am also very grateful.
Honorable members, why?
Mr. Speaker.
Keep quiet.
Mr. Speaker, I am also very
I
grateful.
have asked him to speak on behalf of the leadership. So afterwards.
What is that?
Mr. Speaker, I am also very grateful to the Minority Chief Whip, who is keen on seeing to the development of his first-timers. Minority Chief Whip, may you live long. Mr. Speaker, it is important we emphasize that the principle of separation of powers does not mean that Parliament is inferior to the judiciary. it is very important. The protection which is given by the Constitution, in the same token, hey, you are saying that the African wear is improper dressing. Hey, Mr. Speaker, in the same token, the Constitution also protects parliamentarians. The same token, the Constitution also protects parliamentarians. Mr. Speaker, when you look at Article 117 of the 1992 Constitution, is one of the means by which the Constitution protects parliamentarians. Mr. Speaker, with your indulgence, if I may read, civil or criminal processes coming from any court or place not of Parliament shall not be served or executed in relation to the Speaker or a member or the clerk to Parliament while he is or on his way to attending or returning from or any proceedings of Parliament. Mr. Speaker, the standing orders, Mr. Speaker, even does the job. Starting from Order 25, which is titled Matters Relating to Criminal Processes. Mr. Speaker, it is very important that we emphasize that contempt proceedings are quasi-criminal. In other words, it is like criminal. Mr. Speaker, when you look at Order 25.3, it says that where a member of or the clerk to Parliament is convicted by a court of competent jurisdiction, the registrar of the court shall within 12 hours after the conviction inform the Speaker of the conviction. Mr. Speaker, do you have any notice from the court? No. Mr. Speaker, do you have any notice from the court? No. Mr. Speaker, it is very important. Mr. Speaker, it is very important that we do not go searching newspapers. We do not go looking at newspapers or listening to news to be finding out which member of Parliament has been convicted. Mr. Speaker, that is not our job. Our job, very respectfully, is to come and represent our constituents in Parliament and serve as legislators. Mr. Speaker, if there is any conviction, same will be served on you. Until that is done, Mr. Speaker, very respectfully, it does appear that what we are being fed in this house by the distinguished, by the venerable majority leader, would does appear to be a hearsay. Very respectfully, Mr. Speaker, Parliament does not dabble in ake. Yes, say. Parliament does not dabble in ake. Yes, say. Mr. Speaker, unless there is notice, very respectfully, what has been brought before you, Mr. Speaker, would seem to be ake. Yes, say. Mr. Speaker, Order 25, Rule 5 says that failure of the registrar to inform the Speaker constitutes contempt of Parliament. Mr. Speaker, it may seem that the majority leader is bringing to your attention contempt of Parliament by the registrar of the court. If there is any such conviction, is that what the majority leader is doing before the court? Venerable majority leader, distinguished majority leader, is it that you are bringing to the attention of the court contempt of court by the registrar of the court? Or are you now the registrar? Very respectfully, Mr. Speaker, in the circumstance of this, Mr. Speaker, this Parliament cannot trade in ake to disenfranchise or disallow a member of this house from performing his legislative duty. Very respectfully, Mr. Speaker, I'm very grateful. And in conclusion, I want to thank again the Venerable Anodompre, the MP for Nsawama Dwejiri, for the encouragement he's giving to the backbenchers. Honorable, we are grateful.
Yes.
Mr. Speaker, the honorable member who just spoke, he cited Order 25 of our standing orders. Mr. Speaker, Order 25, 24 deal with the service of processes. We're not talking about the service of processes. We're not. Mr. Speaker, secondly, Order 25 talks about detention. Subject to Order 24, where a member of, or the clerk to Parliament, where a member, please listen, where a member of, or the clerk to Parliament is restricted, detained, or arrested, the person responsible for the restriction, detention, or arrest shall within 6 hours of the restriction, detention, or arrest inform the Speaker of the restriction, detention, or arrest. Has the man been arrested? Has he been restricted? Has he been detained? So how does Order 25 come into play? Mr. Speaker, here we are talking about, Mr. Speaker, here we are talking about a conviction. A conviction. He has been convicted. He has been convicted. Mr. Speaker, I know because he is defending his right to speak here, because he says that even if he has been convicted, if we have not been properly served, then we should not deny him a right to speak in this chamber. That's what he's saying. He is not denying that he hasn't been convicted. Nobody in this chamber is denying that he hasn't been convicted, because they know he has been convicted. It is public knowledge. It is common knowledge. It's been covered widely by the media. And my argument is that this house must respect a coordinate branch of government. We will not arrest him and hand him over to the judges. We will not arrest him and hand him over to the prisons authorities. But we will not condone him coming here and boldly making statements on the floor of this house as if we don't care about the judiciary and what they are doing. It doesn't speak well of the rule of law. There's somebody who knows very well that he has been convicted by the courts for a conduct that he engaged in this house. And we caution him in this house. We say, look, there is a court order restraining you from being sworn in. If you refuse and you allow us to swear you in, you will be held accountable. And he said, yes, he's ready to be held accountable. Now he has been held accountable by the courts, and he wants to come and use this Parliament as a shield. Mr. Speaker, it won't happen. This side will not allow that. We will not allow him to make the statement on this floor, because he has been convicted by the courts. At least he should go and file an appeal. He should file an appeal. He should seek to stay the execution of the orders of the court. Then we know that due process is being complied with. Mr. Speaker, I want to indicate clearly that if you insist and admit this statement and you allow him to make the statement, this side of the house will wash our hands off and then we'll walk out and leave you to make your statements. We'll wash our hands off, because we don't believe in undermining the judiciary. We don't believe in undermining the rule of law. We will not join you to undermine the rule of law. We will not join you to undermine the judiciary. We will wash our hands off and then we'll leave the chamber.
Mr. Speaker, I was watching proceedings from my office, and I heard you call the member for Akwatia to make a statement which you've duly admitted.
Upon calling his name, the majority leader and leader of government business rose up, relying on Order 20 and Article 127 of the Constitution. He argued. First leg of his argument, inviting you to uphold the dignity of this House and generally to help in respecting the independence of the judiciary. Let me say that those submissions he made, though are legal submissions, but I find those submissions very rich in the context that he submits same on this House floor. Mr. Speaker, first, the applicant. In October 2024, a matter arose regarding some vacant seats. I, as a leader of government business, feeling dissatisfied, and upon reading the Constitution, felt that the right place and forum was the Supreme Court. Mr. Speaker, the majority leader, who was a de facto legal advisor to the then minority front bench, was very much aware of the matters in issue. I first sought an ex parte relief. I first applied to the court, invoked the jurisdiction of the court through an ex parte application, and made all the matters known to the court, and the court ruled in my favor. That order of the court staying the decision of the Speaker, which stay of execution allowed the majority to stay in its place, was forcefully challenged with all the energy from the majority leader, who was a de facto legal advisor to the front bench. Mr. Speaker, his side did not respect the Supreme Court. Mr. Speaker, in fact, physically, they moved in to occupy the seat of the majority. Mr. Speaker, after that, the issues were determined after parties had filed. Mr. Speaker, parties filed all their written submissions and argued in court. The AG as the first respondent, the Speaker of Parliament as a second respondent, and when the court finally made a determination, Honorable Mahama Ayariga, MP for Boko Central, as he then was, now he's a majority leader, but then he was not. He was not a majority leader. Mr. Speaker, argued on radio. Mr. Speaker, still challenging the court. And they still occupied our seats, making it virtually impossible for Parliament to sit until after the elections, when they so moto, Mr. Speaker, after the elections, when there was not even any discussion, they got back because they knew they had won, then resumed their seats in the minority side without anybody telling them that go and sit on your own seat. Mr. Speaker, this is the same person who today is talking about law. Mr. Speaker, this is by way of my preliminary observation. Now, let me respond to him on the proper law. Let me now respond to him on the proper law. But as smart as he is, and as I know him to be, when he was landing, he argued some law to create a ventilation for his own argument. And that is that ventilation that I will use to arrest his argument. What was the ventilation? He said, unless the member has filed an appeal and is staying the execution of the order. So, Mr. Speaker, as smart as he is, he created that ventilation. I am able, as a leader of my side, to provide him with that information. That, Mr. Speaker, if his concerns is about the rule of law, this side would always respect the rule of law. The honorable member has indeed filed an appeal, filed a stay of execution, and for your information, there was a stay of proceedings. There was a stay of proceedings application pending before the very judge. A stay of, yes, and you are a practitioner. A stay of proceedings application pending before the very judge. Mr. Speaker, there was also an application invoking the supervisory jurisdiction of the court, of the Supreme Court, under Article 132 of the Constitution. Mr. Speaker, the court below, the High Court in Koforidua, had been served, and the registrar of the court indeed had brought that process to the attention and notice of the judge. Mr. Speaker, our side, even where we disagree, we will not go insulting judges. The fact that we have been quiet does not mean that we think the judge has been fair to us. And you will not see us calling the judge names. We are not like some people. We are not like some people. When we disagree with a judge, we will use lawful process and lawful means to challenge the orders of the court. Mr. Speaker, we are saying that there is a process pending before the court. There is no finality in the matter in issue. The honorable majority leader who raised the matter knows very well that a conviction, even if the member has been served, the judge himself said he was going to have time.
Honorable members, Honorable members. Honorable, hold on. Yes, Honorable Dafeama.
Mr. Speaker, I thank you for the opportunity to intervene in pursuance of Order 1221A. First of all, it is most inaccurate for the minority leader to submit on this floor that the majority at the time, before the general elections of 7th December, we forcefully refused to respect the court order. It cannot be accurate. The terms of the court order were specific. The court orders were directed at the Speaker to perform a certain function. And being the occupier of that seat, we submitted that until that decision was taken by the House. The status quo ante will remain. What was the status quo ante? Our position by occupying the majority side before the court decision. That cannot be erroneous in law. The court itself ordered that the House must take that decision. So for him to submit that we unlawfully, forcefully, and refuse to obey the court order, that cannot be allowed to form part of the records of this House. Tomorrow it can be invoked against us. That's one. Two, Speaker, when you are convicted by a court of competent jurisdiction, you don't file stay of proceedings. They have been convicted. Waters have passed under the bridge. You are convicted. Please, I'm not misquoting you. I heard you clearly.
I was waiting to tell you. I was waiting to respond.
Speaker, I have not yielded the floor to the honorable minority leader. I have not. So you should listen to me in much pain and in silence. I know he'll come back. If you are convicted by a competent court of jurisdiction, conviction, what follows is sentencing. And that is what is pending in this matter. You don't file a stay of proceedings, with all due respect. Now, third, Mr. Speaker, I rose, Mr. Speaker,
Honorable Dafeama.
Mr. Speaker,
Honorable Dafeama.
And with all due difference to my leader, he gave a direction. Yes, by all means, we'll take that. But we will yield the floor. We will not disengage, we will not depart. We will not participate in any proceedings that will allow the honorable member to have locus to make submissions on the floor. It won't happen.
Very well.
Mr. Speaker,
Very well.
so let me conclude by saying that the minority leader, an able lawyer that he is, eloquent that he is, should be advising his colleague to go and respect the court and submit to the powers of, even if you are proceeding to the Supreme Court or whichever court, you need to submit to the jurisdiction of the court first of all. You cannot be doing so as a fugitive of justice. An arrest warrant has been issued, properly issued, for his arrest. That this house cannot gloss over the issuance of an arrest warrant for him and I still permit him to have locus. Mr. Speaker, on this note, we want to urge you that, leader, if I have your permission, let me move that the house be adjourned. The house be adjourned. Let me move that the house be adjourned.
Yes, leader, let me hear you.
Mr. Speaker, let me refer my colleagues to the decision of the Supreme Court on the 18th of October 2024. Mr. Speaker, this is what the Supreme Court said. The Parliament of Ghana is hereby directed to recognize and allow the 4 members of Parliament herein named to duly represent their constituents and conduct full scope of duties of their offices as members of Parliament pending the determination of this suit. Mr. Speaker, in his submission, the Majority Chief Whip said that the court decided that this House should take a decision. The court directed, if people are diluting their law with politics, they should dilute it properly, because these are reputational issues. These are reputational issues. The Supreme Court did not urge upon us to take a decision. It directed. And I submit that they refused to respect the decision of the Supreme Court. That is what they did. And today, I am directly confronting you with that decision you took in October. Mr. Speaker, that aside, in my earlier submissions, my argument was to the effect that prior to the conviction, the court was seized with an application to stay proceedings. I didn't say that the man filed a stay of proceedings. I didn't say the man filed a stay of proceedings pending appeal. I didn't say that. He had a stay. Mr. Speaker, I know some people are at the back there. I am aware they have finished the LLB, and I know they are still attempting to get to the law school. I am a practitioner. Mr. Speaker, I am a courtroom practitioner. I know courtroom practice and courtroom rules. So I'm talking law. And I want my colleagues to listen. I'm saying that Honorable Kumi had filed a stay of proceedings application, which application was pending before the court at the time that the same court was seized with the application committing him for contempt. The court was aware. And I am saying that the court, after its decision, there is a stay of execution and an appeal, notice of appeal. These two processes have been filed. If they don't know, I'm letting them know now. It is most unfair for Mr. Afenyo to describe a respected colleague as a fugitive. Never again should such a statement come out of the mouth of a colleague. Maybe today you find it convenient, but trust me, come on, await each one of us. You cannot describe your colleague as a fugitive. The man has submitted to the authority of the court. Is the reason why he has filed a notice of appeal and has supported that notice with a stay of execution. There is a stay of execution application, a stay of execution. Meanwhile, Mr. Speaker, let me also inform this House that prior to the High Court coming up with that decision, the High Court was again seized with the application invoking the supervisory jurisdiction of the Supreme Court on its conduct, because the registrar of the court had been served and the court indeed was on notice, but the court decided to proceed. We don't mind, because we believe that we can still rely on judicial processes. And I dare say that our side does not take to the insults. We won't go on the radio to insulting judges when we disagree with them. It's the reason why we have been most decent. We will not go attacking a judge on social media and be using unprintable words on judges just because we disagree with them. No. Mr. Speaker, the invitation to you to restrain the member from making his statement, Mr. Speaker, is most unfair. That invitation sits on stilts. That invitation is not based on any solid foundation in law. And Mr. Speaker, an attempt to be hoodwinked into any valley of confusion would amount to a general confusion in this House, because the majority leader knows that he was only doing politics and not doing law. He knows that what he did was politics and not law. Mr. Speaker, in this House, how can a member of Parliament who in the performance of his parliamentary duties has not been served with the court process? Mr. Speaker, let them sit quietly and listen. Let me finish my submission. Mr. Speaker, if they want, then we should. What? Yes. Well, that's all right. Mr. Speaker, it is clear that the NDC side, when they talk, they don't want anybody also to have this opportunity. It was started by you. I am responding to your argument. Why? We cannot respond to you.
Honorable Minority Leader, you let me listen to him. I'll come
Mr.
back.
Speaker, he has to finish. He has to listen to me.
I'll come back
If
to
he has
you.
a point of reply, he must.
Honorable members.
When Afenyo Markin speaks, many of you will get
Honorable
that.
members.
When Afenyo Markin, many points of order.
Honorable members.
Where? Many points of order.
Honorable members.
You cannot
If
tolerate.
you wouldn't allow me, I will go ahead, suspend the house, and
You will not adjourn the house. Mr. Speaker, they want an adjournment. We would argue the case today. We will argue no adjournment. Mr. Speaker, we will argue. Let us argue the issues with the adjournment.
Honorable
You want an
members.
adjournment. You are running away. You brought your
Honorable
application, you are
members.
running away.
honorable
You
members,
brought your application, you are
the
running
time
away.
is 5 to 4 o'clock. You are in my hands. The house is accordingly adjourned.
Read your statement to the end.
You cannot read your statement.